give a warm S2S welcome to Dr. Daniel Sims.
Thank you. And Danachea, as I've been introduced, my name is Daniel Sims. I'm from SAICA, and today I'm talking about the impacts of the Indian Act. It's important to bear in mind that the Indian Act was originally passed in 1876, but when it was passed in 1876, it consolidated previous acts. So it was bringing acts together. It is still part of Canadian legislation to this day, and when we use the term status, it is still legally Indian status here in Canada. So as a status Indian, I have a piece of plastic in my wallet that says that I am an Indian under the Indian Act, and then lists what nation I'm a part of, and a number of other details regarding my life. So just looking at the Indian Act itself, it is a piece of federal legislation, and that's important to bear in mind. It's not provincial. When Canada confederated in 1876, Indians and lands reserved for Indians were made a federal responsibility. This wasn't necessarily guaranteed. So when Australia united in 1901, Aboriginal people were placed under the jurisdiction of the states, not under the federal government. So that decision was made. And it has complicated things because, again, it's federal, but a lot of the services that Canadians rely on are provided by the province or the municipality or the regional district or county or parish, depending on what province you're living in. So there is that aspect that comes into play. It's also been amended numerous times. So when we talk about the Indian Act, there's the original Indian Act of 1876. It's been amended numerous times since then. And some of them do implement different things that are considered restrictive. Others simply remove things or add things, depending on your interpretation. Those can either be restrictive or beneficial. So a good example of that would be, under Stephen Harper, a whole bunch of sections of the Indian Act that dealt with residential schools and restrictions that were no longer being enforced were simply removed from the Act itself. So, yeah, considered to be a good thing in that way. It's also important to bear in mind the Indian Act does not apply to the Métis or to the Inuit. So both are a federal responsibility. There's been Supreme Court cases that have clearly defined that they're a federal responsibility, that they do fall under the category of Indian under the British North America Act 1876. But neither fall under the Indian Act, and neither want to. So that's another important aspect to bear in mind. Neither the Métis or the Inuit are pushing for the Indian Act, even if they are pushing for programs that might be provided by Indigenous Services Canada or Indigenous Crown Relations. So there is that aspect to bear in mind. Just looking at kind of the history of the Indian Act, or what actually led up to the Indian Act, it's important to bear in mind that a lot of the things that we associate with the Indian Act existed prior to it. So in 1620, we have the first residential school. The Indian Act would later talk about residential schools, regulate the residential schools, and mandate that Indigenous people had to attend residential schools. But the residential schools existed before the Indian Act. Same issue with reserves. So first reserve, 1627 in Sillery, Quebec. Again, long before the Indian Act itself. So there is that distinction that exists. The Indian Act eventually would come to actually talk about who could be on a reserve, who could not be on a reserve, and define not only status, but band membership with regards to both. And then even things like treaties. So we have Dummer's Treaty in 1725, one of the first peace and friendship treaties in Atlantic Canada. And treaties, again, were signed outside of the Indian Act itself. And if we do away with the Indian Act, it doesn't necessarily mean that we're doing away with treaties. And there actually have been a number of modern treaties signed in British Columbia in the last 20 years where the nations have done away with the Indian Act. They've done away with reserves, they've done away with status. The Slamin Nation by Powell River is a good example of that. So they're no longer under the Indian Act. They no longer have status, they no longer have reserves. But there are some nations that have kept the Indian Act with modern treaties but removed certain sections. The Nisga'a are a good example. The only section they kept was with regards to status. So there is that aspect comes into play. Again, moving from the peace and friendship treaties, we have the Upper Canada treaties, which really set the stage for the treaties on the prairies. So this is Ontario, 1764, the Treaty of Niagara. And there would be numerous other Upper Canada treaties that would be signed well before the Indian Act itself. When I mentioned the Indian Act, when it was passed in 1876 and consolidated previous acts, these are some of the acts that it consolidated. So in 1839, the Crown Lands Act was passed. This placed reserves under Crown control. So prior to this point in time, from an Indigenous perspective, reserve land was Indigenous land. It wasn't under federal jurisdiction, it wasn't under colonial jurisdiction, it wasn't under imperial jurisdiction. It was Indigenous land writ large, with the colonial government not really having a say on it. In 1839, the colonial government in what is today Ontario and Quebec decided to pass a piece of legislation that clearly established that lands reserved for Indians were under colonial jurisdiction. And with Confederation, this would become something that was under federal jurisdiction, not provincial jurisdiction, which again creates problems because many of the services provided are provided at a provincial level, not a federal level. Furthermore, in 1850, the Protection of Lands and Property Act, which was passed in the province of Canada, established status. So the act itself, in a certain sense, was meant to protect Indigenous lands, although I do say that with some caution. But one of the ways that it sought to protect Indigenous lands was to clearly define who was legally an Indian and who was not. Again, so status predated the Indian Act, although the Indian Act would consolidate it. The initial definition of status was tied to men. So you either were an Indigenous man, the spouse of an Indigenous man, or the child of an Indigenous man, either biologically or through adoption. So one of the things people often point to with regards to the Indian Act is that those definitions of who had status and who didn't have status, they did change over time, but it was until 1985 purely based on being a man, not being a woman. So a lot of Indigenous women who lost status as a result. In 1857, you have the passage of the Gradual Civilization Act. This was a way for people to actually get out of having Indian status. So by having Indian status, you were considered to be a ward of the crown, and therefore not considered to legally be an adult. You were a minor. The one way to get out of that was to enfranchise. So prove to the colonial government that you were quote unquote properly civilized. There are a number of ways that this could occur. Getting a university education was one of them. Becoming a priest was another one. Having property of a certain value was another. And again, when we talk about reserves, one thing that people often forget is that reserve property is held in common for the most part. So people don't necessarily own the land they live on as an individual, although they own it as part of a nation. So again, there's that aspect that comes into play there. In 1860, there's the Indian Lands Act. This creates a lands commissioner. So not only are reserves now under federal jurisdiction, but now there's a department in the colonial government that is actually handling how lands are administered on reserve. And this would be something that Indian Affairs would eventually take over. So getting into Confederation, one thing that's important to bear in mind is the Confederation brought together 3 British colonies, the province of Canada, the province of New Brunswick, and the province of Nova Scotia. So those were the legal names of them for obvious reasons. In K-12, we often don't refer to them as provinces to avoid that confusion. But the policy of the province of Canada became the policy of Canada when it came to Indigenous peoples. And this was a policy of treaties, this is a policy of reserves, and it was a policy of status. So if you go to Nova Scotia, if you go to New Brunswick, they did have reserves, but reserves didn't belong to an individual nation. They belonged to all of the First Nations people in the colony. So there wasn't that division in that sense. Similarly, they had treaties, but they were peace and friendship treaties that didn't deal with land, not the Upper Canada treaties, which very clearly dealt with land. So there is that changing definition that comes into play. The only exception would be that in 1871, when British Columbia joined the new Dominion of Canada, it got a guarantee that its existing Aboriginal policy would continue. So this is something that often people overlook, is not necessarily covered in K-12, but when the various colonies joined Canada, they negotiated their entry. So BC guaranteed a number of things, most notably, and the one that often comes up is the CPR. So a railway would actually be built. Ones that don't come up so much are higher than per capita transfer payments from the federal government and the continuation of Aboriginal policy. And in BC, Aboriginal policy didn't include treaties at that point in time. So it did include reserves, didn't include status. So there was some difference there. And this would lead to conflict between the new federal government and the provincial government. Furthermore, with Confederation, as I've mentioned, Section 91, subsection 24, clearly states that Indians and lands reserved for Indians are a federal jurisdiction. So there's that clear language that comes into play there. The Métis and the Inuit have had court cases that clearly indicates that they indeed fit within this category, although not under the Indian Act. One of the outcomes of placing Indigenous affairs or Indian affairs under federal jurisdiction is that we did have the creation of a department to deal with Indigenous peoples. Today it's 2 departments, but the department has waxed and waned as time has gone on. It's been in different ministries, not necessarily named Indian Affairs. In recent years, the language surrounding the name of the department has been changed as an attempt to indigenize, although it's not entirely clear that that has actually worked. So kind of beginning, going back here, wrong button. It started out as part of the Secretary of State for Canada, moved to the Secretary of State for the provinces, then to the Department of the Interior, then from 1880 to 1936, it was the Department of Indian Affairs, which is what it would be known as colloquially, arguably to the present day. Then in 1936, it was moved to the Department of Mines and Resources, then to Citizenship and Immigration, then Northern Affairs and National Resources, then Indian Affairs and Northern Development, Aboriginal Affairs and Northern Development, Indigenous Affairs and Northern Development, and more recently to Crown Indigenous Relations and Northern Affairs and Indigenous Services Canada. So it has existed in various forms. It's also been led by some rather prominent individuals. So John A. Macdonald was the Minister of Indian Affairs twice. When we talk about residential schools, he was the Minister of Indian Affairs when they came into existence. He talked about the purpose of residential schools, not only in the House of Commons, but also while campaigning, in no small part because the Liberals felt like it wasn't a good policy. That being said, when the Liberals got into power under Alexander Mackenzie, or later under Wilfrid Laurier, they did not end the residential school system. So there was some back and forth there. And indeed, Wilfrid Laurier was Minister of Indian Affairs, as was R.B. Bennett, Prime Minister of Canada during the Great Depression, Conservative Prime Minister, Arthur Meehan, Conservative Prime Minister in the 1920s, and then Jean Chrétien. So Jean Chrétien would be Minister of Indian Affairs when the infamous white paper would be proposed. So if you're not familiar, and I imagine most of you are, a white paper is simply a policy proposal from the federal government. He was the minister who put that forward with Pierre Elliott Trudeau. A lot of unrest, a lot of anger resulting from that, and actually led to the creation of a number of Indigenous organizations to push back against it, including the Lakes District Council, which eventually becomes Carrier-Secani here in northern British Columbia. And then kind of moving into the more recent period, Jim Prentice was Minister of Indian Affairs under Stephen Harper, later become Premier of Alberta, and Ellen Fairclough, the first female minister in Canada. So again, as a department, its importance has waxed and waned, but it hasn't necessarily been a department where people have been minor players in the government. Some of them have been rather significant. To say the least, looking at the Indian Act itself, it helped create a system of surveillance via Indian agents, farm instructors, and other federal officials. So here in northern British Columbia, we have the Stewart Lake Agency for most of the late 19th and early 20th century. It would have one Indian agent administering the various reserves here. When you get onto the prairies, it might be one Indian agent per reserve. So it did vary from place to place, but the purpose of the Indian agent was to implement the Indian Act, implement Indigenous policy, and they even had a guide. So I actually have a guide in my office. I probably should have brought it today, but I got that from a colleague at the University of Alberta whose grandfather was an Indian agent. And so as part of his job, he got a thick binder outlining how to actually be an Indian agent, everything from how to administer wills, to registering trap lines, to enrolling children into residential schools, all laid out there. And the policy book would be updated year in, year out. It also consolidated things like the Gradual Enfranchisement Act. So this is an act that was passed mere 7 years prior to the Indian Act in 1876, but one of the key aspects of it is it brought in this provision that if you were an Indigenous woman and you married a non-status man, you lost your status. And this would be part of the Indian Act until 1985. So it didn't matter if your partner was Indigenous, what mattered is if your partner had status or not. So there's that aspect that comes into play. It also created the band council system. So again, Indigenous people had had their own governance structures for thousands of years. Some of them were parallel to the band council system, others were not. But this created a one-size-fits-all approach to Indigenous governance that a lot of Canadians weren't particularly aware of until the recent protests regarding pipelines in northern British Columbia, when people suddenly heard of hereditary chiefs. Who are they, what do they do, and how come they don't agree with chief and council? Ignoring the fact that sometimes hereditary chiefs are actually forming chief and council. So it does vary from nation to nation, community to community, but the Indian Act created this one-size-fits-all approach, and again, consolidated a whole host of previous acts So looking again at how status was actually defined, the Indian Act updated the 1850 definition by simply stating that men could give status via marriage. So this is something that's important to bear in mind. From 1876 until 1985, if you married a man who had Indigenous status or Indian status, you got status. It didn't matter what your ancestry was, you just had status. And because the law was only changed in 1985, there are people in Canada to this day who are status Indians who have no Indigenous ancestry at all. They simply married somebody who had Indigenous ancestry or who had Indian status. Similarly, as I mentioned, it contained the provision that if you marry somebody, you're an Indigenous woman, and you marry a non-status man, you lost your status. So a very clear distinction between men and women contained in the Indian Act itself. You could also, as I mentioned, lose status via education, becoming a doctor, becoming a lawyer, becoming a priest. So again, these would remain into effect until 1985 in the first two, 1961 in the third. And the Indian Act also gave Indian agents the power of the purse. So they could control how Indigenous funds were spent. So when we talk about things like development on reserve, a lot of people ask how come reserves aren't as developed as other communities. A big part of that can be tied to the fact that the Indian agent didn't feel like it should be developed. So when we talk about a bridge across the Fraser River from one half of the reserve to the other half of the reserve, yeah, in a certain sense, it just wasn't built. In another sense, it wasn't built because the Indian agent for Clay-Clay-Tenay, at least until 1951, didn't think it was a matter that was important. And after 1951, maybe still didn't think it was a matter that was important because until 2014, Indian agents or Indian Affairs had the power to approve bylaws, band council resolutions passed by First Nations. So by 2014, they rarely disallowed them, but they still had that power that came into play. Just continuing looking at the Indian Act, some of the restrictions that are imposed. So in 1880, the Indian Act was amended to give Indian agents the power to remove chief and council. So again, this creates an interesting situation because in theory, at least the way the law is written in English, this is to remove bad chiefs and councils. In reality, the definition of bad was up to the Indian agent, which meant that if there is a chief or a council that was pushing back against the Indian agent, didn't want to follow Indigenous policy, didn't want to send their children to residential school, the Indian agent could simply remove them and call a new band council election until they got the person who would actually agree with what they did, at least outwardly. Furthermore, in 1880, the federal Department of Indian Affairs gain control over funds. So it's not just the Indian agents, the department itself. This reflected the fact that some Indian agents weren't actually doing their job from the perspective of Indian Affairs. So now it would be the federal department that has control over spending for Indigenous peoples. And even to this day, Indigenous Services Canada has bank accounts for almost every First Nation in Canada that is full of money that the First Nation has generated during its history. So it's not the same for every First Nation. There's different amounts in different bank accounts, as you would imagine, but they still exist in that sense. In 1881, the idea of a permit system was proposed, and the concept was really introduced in the Indian Act. This was a system whereby status Indians could not sell crops or livestock without getting a permit from Indian Affairs, from the Indian agent, or from the farm instructor. So on the one hand, particularly on the prairies, they're telling Indigenous people you need to farm. Well, on the other hand, they're saying, well, you can only sell your crops, your livestock, when we tell you you can. No sooner, no later. And if you do, you are breaking the law. These restrictions were put into place, particularly with regards to the punishments in 1884. And it's also in 1884 that most ceremonies were banned. So the potlatch here, the sun dance on the prairies, any sort of Indigenous ceremony was just outright banned. So that restriction was placed in place. And then education was also made mandatory. So Indigenous children have to go to school. At this point in time, it didn't necessarily say residential schools. The residential school system had only started the year before. There weren't that many federal residential schools in Canada yet, but it was mandated that Indigenous children had to go to residential or had to go to school. And then in 1885, you have the implementation of the pass system. So the pass system was never part of the Indian Act, but it was in response to the Northwest Resistance or Northwest Rebellion. And this is a policy by which if Indigenous people wanted to leave the reserve, they had to get a permit from their Indian agent. So heavily enforced in the prairies, less so in the north, but it was something that existed until 1941, and arguably into the 1960s. So I'll just continue with some of the amendments. So in 1886, the Indian Act was amended so that if you're off reserve for 5 years without permission, particularly outside of Canada, you lost your status. And this would be used against Indigenous veterans in World War I and World War II. So Indian agents was determined that they had fought in Europe or in Asia without permission, and therefore they had lost their status. So there is that aspect that comes into play. Furthermore, the permit system was further strengthened. So simply laying out that, again, you can't sell your crops or livestock without having permission from the Indian agent. In 1894, the ban on ceremonies was strengthened as well. So making the punishments harder. Barring things that might be related to ceremonies that aren't necessarily part of ceremonies. Furthermore, attendance at residential schools was made compulsory. So it's no longer your children have to go to school, it is your children have to go to residential school if there is one available. And Indian Affairs defined that by there being space in a residential school, not necessarily space in a residential school near you. So a lot of residential school survivors actually attended residential schools very far from home, whereas others actually attended residential schools relatively close to home. It just was a matter of space and where Indian Affairs decided you wanted to go, or not necessarily where you wanted to go, where they wanted you to go. In 1895, the Indian Act was further amended to allow Indian Affairs the right to depose chief and council. So it had been the Indian agent prior to this, now is Indian Affairs. They could simply get rid of chief and council if they didn't like what chief and council was saying. So again, things are getting tighter and tighter. And then in 1905 or 1906, depending on how you want to date that, the Indian Act was amended to allow for the removal of reserves near urban centers of 8,000 or more. So again, when we talk about Lheidli T'enneh, this is part of that. The Indian Act was passed to allow for reserves to be removed from centers of non-Indigenous populations. So again, in the case of Lheidli T'enneh, there was the agreement, and I use scare marks there. That was often the case, some sort of document that would make it appear like the nation was okay with what occurred, but the document would be under duress, or in some instances, potentially forged. So we look at Chesalata, for example, and the agreements they had for the flooding of their traditional territory, or in the case of my nation with the WAC Bennett Dam, they just forgot women existed. So they said, oh, the majority of the nation has voted in support of getting a new reserve, not necessarily being flooded out, but they didn't ask any of the women. At that point, women did have the vote when it came to band council resolutions. So huge issue there in that aspect. Just kind of continuing, so 1910, Indian Affairs assumes control over self-funded claims. So what does this mean? This means by this point in time, Indigenous peoples in Canada are wanting to take Indian Affairs to court over their treatment. Indian Affairs changes the Indian Act in 1910 to state that if an Indigenous group or Indigenous individual is going to file a claim against anyone, they have to have the permission of Indian Affairs to file that claim. So in essence, it meant no, you can no longer sue Indian Affairs. You can't sue anyone. Indian Affairs has to approve that. In 1911, Indian Affairs simply, again, amended the Indian Act to give itself the power to sell or lease reserve land. So it's not simply we can remove your reserve if you're close to an urban center. It is now we can sell or lease your land without actually getting permission from you. One of the interesting aspects in recent years has been that a lot of the land that was leased or sold, or particularly leased, I should say, in 1911, came up for renewal. And so these leases that were for an extended length of time are suddenly being renewed by nations that are not interested in what the market value was in 1911. They're interested in what the market value is now. And so a lot of people across Canada, Kamloops being a good example, or Powell River, who suddenly found that their very good deal when it came to actually leasing land from the reserve was no longer a good deal. So there was that transformation that occurred. In 1914, the Indian Act was amended to ban traditional clothing. So this is part of strengthening the ban against ceremony, because Indigenous people weren't respecting the ban on ceremony, and they shouldn't. But Indian Affairs' solution was, okay, we've already made it illegal for you to practice your ceremonies, we've strengthened it, increased the fines, increased the punishments. We're now just going to simply make it illegal for you to wear traditional clothing, because you're probably going to wear that traditional clothing to ceremonies, It should be noted that Indian Affairs did allow certain groups to still wear traditional clothing for very controlled purposes, the Calgary Stampede being a good example of that. So the nations in southern Alberta were allowed to wear traditional clothing during the Stampede, but not after or before it. 1919, the Indian Act was amended to give Indian Affairs the power to control mining on reserves. So not only can they lease the land, not only can they sell their land, not only can they relocate reserves if they're close to urban centers, now Indian Affairs can approve mining on reserve, regardless of what the nation actually wants. 1920, the compulsory attendance at residential schools was strengthened. It was strengthened in one big way. Prior to this, you had to go to residential schools. With this amendment of the Indian Act, the RCMP, the Indian agent, the farm instructor, now had the power to enter any structure where they thought that Indigenous children were being kept. So Indigenous, non-Indigenous, they could now enter anyone's home, anyone's business, and search for Indigenous children without a search warrant, strengthening, again, the provision that you actually have to go to residential schools. That was on the books until 2014. So as part of Stephen Harper's amendment to the Indian Act itself. In 1927, the Indian Act was amended to simply ban the hiring of lawyers by Indigenous peoples. So it didn't matter if Indigenous people paid for the lawyer, it was simply you can't hire lawyers to push forward claims for Indigenous peoples. And this was in response to the earlier ban, saying the Indian Affairs had control over whether or not you could actually hire a lawyer if you're using banned funds, because some Indigenous peoples have been working around that to actually crowdsource, as we'd use it today, to gather funds from their supporters to hire lawyers to take on the case on their behalf, but not directly. So this would be part of the so-called Great Settlement. It's not called that anymore, but from 1871 to 1927, British Columbia and the federal government had fought over Indian lands, fought over reserves, fought over treaties. This led to the McKinnon-McBride Commission, it led to the Ditchborn-Clark Inquiry, and it led to an amendment of the Indian Act in 1927, where Indigenous people simply could no longer have a lawyer hired for them or hire a lawyer in their defense. So, in 1933, dances were banned. So again, ceremonies have been banned, the punishment against ceremonies have been strengthened, traditional clothing has been banned, now Indigenous people are not allowed to dance unless they have permission from Indian Affairs. So this again was to get around the fact that the Indigenous people were resisting this ban. And so simply making it a crime to dance meant that Indigenous people could say, well, we're dancing, but we're not actually dancing in a ceremonial manner, we're just dancing. So that ban came into effect. And then in 1936, the Indian Act was amended to give Indian agents a seat on the band council, as well as a vote on the band council. So they already have control over funds, they can already oppose chief and council, now they can vote on band council. So, and then kind of finishing out here, and there's more amendments than the ones I'm actually covering. Some of them, again, are just clarifying certain things or changing them from year to year. These are the ones that are particularly restrictive. In 1951, you have the first amendment to the Indian Act that has anything close to feedback from First Nations. So most of the restrictions that I mentioned were lifted in 1951. Some of them were only lifted in 2014. A big part of this was that in 1951, when the Indian Act was amended, Indian Affairs actually got feedback from Indigenous peoples. Didn't mean that they used all that feedback, but they got some feedback. So a lot of the restrictions were lifted. Part of this, too, was this transformation of Indigenous peoples in Canada, and reflecting that in 1960, the federal franchise was extended to Indigenous people without them losing status. So Indigenous people are now able to vote in federal elections. Provincially, it varied from province to province. So in BC, it was 1949 provincial elections. In Quebec, it was 1969. And in some provinces like Newfoundland, which was its own separate dominion until 1949, but another province like Nova Scotia, which is part of Canada since 1867, there technically was no restriction in place. It was simply an unofficial segregation of the vote. So again, having the power to vote on the books doesn't necessarily mean that the polls are going to welcome you with open arms and say, come, please vote. Then kind of continuing, in 1971, assimilation ceased to be the official policy of Indian Affairs. This is in direct response to the White Paper. So the White Paper is put forward to end the Indian Act, to end treaties, to end reserves, to end status, to end Aboriginal rights. Indigenous peoples across Canada were not happy with this proposal. Groups like the Union of BC Indian Chiefs put forward the brown paper. In Alberta, there was the red paper. Almost every province had some sort of policy paper in response, in opposition to the white paper. And in 1971, Pierre Elliott Trudeau and Jean Chrétien said, yeah, we're not putting it forward. This is a dead policy. Again, a lot of people think that it isn't actually a dead policy, that it's simply going to be implemented in a very slow way, in a slow manner. But a very optimistic view is that this is when assimilation ends as a policy in Canada. At least that's what the federal government is saying. So just looking at the impacts of the Indian Act, it's important to bear in mind they're not needed for treaties. So the Douglas Treaties in British Columbia were signed prior to British Columbia joining Canada, and they were signed prior to the Indian Act existing. So yeah, again, the Indian Act is not needed for treaties, and a lot of the modern treaties in British Columbia have done away with the Indian Act. So, and if anything, the Indian Act is somewhat related in the sense that it deals with Indigenous peoples, but they're not connected in that sense. It's also not necessary for Indian status. So Indian status existed before the Indian Act. It existed since 1850. It could continue if the Indian Act was abolished. So there'd have to be another piece of legislation, but again, that could simply be a piece of legislation that outlines how people actually get status. It's also not needed for reserves. So when we talk about reserves in Canada, they existed well before the Indian Act. And we talk about reserves in Canada, we forget that non-Indigenous people had reserves too. So during the settlement of Western Canada, there was an Icelandic reserve in northern Manitoba, and there are also Mennonite reserves on the prairies that were established. So those have ended now, although the East and West Reserve are still used colloquially in southern Manitoba to refer to Mennonite settlements. So again, reserves aren't tied to the Indian Act, and they're not necessarily tied to being Indigenous. So it's just a certain category of land. Again, it did subsume Indian status, so it's complicated, and as I've mentioned, more and more modern treaties do away with it. So they do away with not only the Indian Act, they also do away with status and reserves. Again, what is another impact on a national level? There is that aspect of control. The Indian Act did not recognize the First Nations are autonomous, let alone sovereign. So for many years, the Indian agent had the power on reserve, not the chief, not the council, and the nation was helpless to actually really do anything short of open rebellion, which would have just resulted in the RCMP, if not the Canadian military, invading the reserve and killing people, as happened with the Métis on the prairies. It did force the chief and council system on all First Nations. Again, this is something that's important to recognize. Some First Nations are okay with this, other First Nations are not. And part of indigenization or reconciliation is coming to terms with that. So the Haudenosaunee, for example, also known as the Iroquois, have a traditional governance structure of 60 hereditary chiefs. It's their Congress, people inherit the name, but they inherit the name based on the women of the community actually selecting them to inherit the name. So it is democratic in that sense. That governance structure still exists to this day, but it is divided between the United States and Canada. So, yeah, how do you actually reconcile that issue? Again, until the mid-20th century, Indian agents could and often did have dictatorial powers. So, a lot of power, a lot of control. Varied from nation to nation. After the mid-20th century, First Nations often were blamed for the failures of Indian agents. So again, there's a lot of blaming of Indigenous people given the current situation they find themselves in. A lot of it isn't necessarily something that they were responsible for or had any control over. And simply were left with the mess when the Indian agent left. So it's also important to bear in mind that third-party management is still an option. So when we talk about Indigenous peoples, yes, the Indian agent is gone, but if Indian Affairs or Indigenous Services Canada feels like your nation isn't properly handling its finances, it can take over control of the nation, place it under third-party management, they can place it under co-management, they can place it under supervision. And one of the interesting aspects of this is that most First Nations in Canada run a surplus every year. And we know this from Stephen Harper's First Nations Financial Act, where First Nations who receive federal funding were asked to actually submit audited financial statements that anyone could view. And yeah, even the poorest First Nations in Canada still run a surplus. Out of that concern that they run a deficit, Indigenous Services Canada will simply assume control. So there is that impact that comes into play as well. Looking at the individual, so again, control the individual. Under the past system, kept on reserve. So this limits not only your social activities, but also your economic activities, your educational activities, even your cultural activities. So there is that factor comes into play. With regards to the social, it also can lead to the breakdown in connection between communities. So this reinforcement of the idea that, say Sekadene is completely different than Kwadacha, even though Sekadene and Kwadacha have the same families. So we're just different because we're different First Nations. We have different reserves, even though, yeah, half my family's on one reserve, half is on the other reserve. So there's that separation there. Also control of forcing Indigenous children into residential schools. So we talk about the force, it was part of Canadian law. The Indian Act regulated what could be done to actually force Indigenous children to attend these schools. For parents, it would be going to jail. They'd be receiving a fine. And eventually we come to the point where the RCMP, the BC Provincial Police, Indian agent, farm instructor could enter anyone's house to look for Indigenous children if they felt like the children were being hidden to prevent them from going to residential school. So a major breach of people's privacy. And again, as I mentioned, there's that aspect over the economic future. So how do you find a job if you're kept on reserve? And how do you find a job if the only education you received is from the residential school? Because residential schools were not good at actually educating Indigenous people by any stretch of the word. So there's that aspect that comes into play. Enfranchisement was an option to escape controls. I had that in scare marks. That was the intent of the federal government. So if you don't like all of these restrictions, just give up your Indian status. Which also meant you're no longer allowed to live on reserve. You're no longer a band member. You're no longer eligible for any sort of social programs for Indigenous peoples. And you now simply have to move on with your life. And in some instances, you might simply take a part of the reserve with you. So reducing the land base for the rest of your community in that sense. Again, historically, loss of Indian status meant loss of connection to the First Nation. And in 1985, when the restriction requiring Indigenous women to give up status if they married non-Indigenous men was lifted, it occurred at the same time that status was separated from band membership. So right now in Canada, you can have status and not have band membership, meaning that you're a status Indian, but you have no connection to community in a legal way. Or you can have band membership without having status, depending on the requirements of band membership. So there is that separation that exists there. One of the obvious things with regards to status and not having band membership is that everyone's status number clearly identifies what nation they're from. So the first 3 digits of the number on your card indicates your nation. Mine is 609. If you are 900, it means that you have no First Nation. You just have status. So yeah, if I go to Clayton-Tenay, if I go to the gas station later today, and if they look at my status card number because I want to get tax-free gas, they automatically know that I'm not from Clayton-Tenay because I don't have the same band number as them. I'm 609. And if I go in there with a 900, automatically know that I don't actually have a First Nation at all. So another big issue with regards to enfranchisement is that the alleged benefits were not guaranteed. So what was being promised on paper was that if you gave up your Indian status, you would be like every other Canadian, and they would welcome you with open arms. The reality is that that was not the case. So in the eyes of many other Canadians, you still were an Indian, and you still were discriminated against, but you simply no longer had a community to support you. You no longer had reserve land to live on, and things like that. Kind of looking at community. So what are the impacts of the Indian Act? The big one with regards to federal jurisdiction and provincial jurisdiction is that, as I mentioned, many of the services that we take for granted are provincial. So healthcare is provincial, education's provincial, roads and highways are provincial for the most part, infrastructure is largely provincial, and because Indigenous people, status Indians, reserves for federal land, it meant that the provinces weren't responsible for them. It meant the municipalities weren't responsible for them. It meant the regional districts weren't responsible for them. We talk about boil water advisories in the country. There's an assumption that most of them are in remote communities, far away from any sort of urban population. The vast majority of them are in Ontario, and they're right next to major urban centers. And what happened was that in the 1800s, when those urban centers put in waterworks, they stopped at the reserve, because the reserve was not under their jurisdiction. This is true even in Western Canada and more recent non-Indigenous communities like Edmonton or Calgary. So there's a history of simply cutting off services at the boundary of the reserve, in the case of Calgary with the Tsuut'ina, and in the case of Edmonton with the Enoch First Nation. So in recent years, there have been changes, there have been moves to actually connect the reserve to the community. Sometimes this is through negotiations, sometimes it's through the nation actually having power. So in the case of Calgary, they wanted to build a ring road. They wanted to build the ring road through the Tsuut'ina Reserve, and the Tsuut'ina simply said, no, we're not going to let you build a ring road through our reserve unless you actually hook us up to all the services that you provide to everyone else in Calgary. So again, having that power, having that ability is good. Reflecting this federal responsibility, it's also important to bear in mind the federal government, because it was responsible for Indigenous peoples, but because education, healthcare were provincial responsibility, they basically created their own systems. So when we look at the residential school system, rather than work with the provinces to make sure Indigenous children could be in provincial schools, the federal government simply created the Indian residential school system. The same is true with regards to Indian hospitals. Rather than work with the provinces to make sure that Indigenous people would go to provincial hospitals, they created their own hospital system. And it wouldn't be until the mid-20th century that the federal government would begin talking to the provinces about education, about healthcare, and actually work out agreements where Indigenous children could attend provincial schools. But even to this day, the funding for those students is provided by the federal government. And in the healthcare system, the funding is provided by the federal government. So, one of the end results is this creation of two solitudes. So, yeah, it's great that we're here. It's great that you're meeting with Lake Lheidli. I'm really happy that's actually happening. I'm being sincere. But for most of the 20th century, Lake Lheidli or Shelley or Fort George Band was viewed as those people over there. We know they exist. But we don't need to interact with them in any meaningful way. So, and the sheer amount of people who don't understand the history behind the Memorial Park, or the fact that in the middle of that park there's a reserve, is stunning in this city. So again, go into that reserve, you're on federal land in that sense. Again, integration starts in the 1950s, it continues to this day. So there's that push towards integration. And this brings me to the conclusion of my talk. Are there any questions? Yeah.
Sorry, Dr. Sims, I'll get everybody to put your hand up. I'll run the microphone over because we all want to hear your questions. Okay, I think Wendy was first.
You mentioned a lot about federal and provincial. Even though we're under federal, we still have to follow provincial laws. Why is that?
So, according to the Supreme Court of Canada on reserve, you don't. But the provinces haven't agreed with that. And off reserve, you do. So, yeah. Yeah, and that's one of the aspects of kind of the division of power. Because you're not on federal land, you're following provincial law. So it's the same rationale as if you move to, say, Alberta, you have to follow Albertan law as opposed to BC law.
Because my programming, I'm the social assistant for on reserve. I have federal, that the monies is federal and everything is federal, but I have to follow provincial guidelines.
Yeah.
And that makes it really confusing for the clients. Like, why do we have to follow provincial? Like, they changed all that. So what I'm trying to get at is, why is it called federal and provincial when federal technically doesn't exist, because we have to follow provincial laws?
Yeah, again, that's one of the things that I think might come up in a court case in upcoming years. It came up with regards to hunting and fishing, with regards to the Bob case here in British Columbia, where the province argued that hunting and fishing regulations extended to the reserve, and the Supreme Court said no, they don't. In these instances, it could be something that's subject to a court case, because it is an overreach of the province, but it would be the federal government or the nation that would have to actually take that.
Hello, my name's Tamara Seymour. I'm the health manager for Lake Lheidli. And going off a little bit about Wendy, with my funding as well, the difference between provincial, most of our members live on provincial. So I guess one statement I'd like to make in the collaboration of what we're doing today is, how do we work within the policies that were mandated so long ago and make it work for today and the future of our generation? So I think like what we discuss and these relationships that we make today is just that. how do we blur this line between provincial and federal funding? But that's not what I was gonna say. I just want to raise my hands to you. I took a lot of notes. If you do classes, I'd love to take one of your classes. But I just wanted to note when you spoke about the Memorial Park and really understanding the meaning behind that. In one of my recent classes I took, I chose the Memorial Park as one of my projects because, you know, although it's great that it's titled the Memorial Park for Clately Tenay, but we have a graveyard in there, and when we lose a community member, we close down our offices and our community in respect to that family and that member who we have lost. But yet when we go into bury that member, there's an entire park going full force, children playing, playground open. And I would like to put that in front of us all today and how we can work together and, you know, really understanding our protocols of the respect of death in our community and how we can make that a little more positive for our people. That was one note. But I just feel like your presentation as a whole is so essential as we walk towards reconciliation, because in order for reconciliation, we really need to understand the past, and the past is the colonial governments and the Indian Act and the impacts that we're still seeing today. I think of my daughter and my son. I didn't get married, but I almost got married to a non-Indigenous man. And to think back, if we still had these acts in place, I would no longer be an Indian status member, but yet I wouldn't be a Canadian citizen. And yet, so just really thinking, I feel like I was really triggered through this presentation. A lot of anger arose in me. And it's actually making me realize like where my passion lies when it comes to the governance and legislation. So I think keep doing the work that you're doing, and I just hope that across our country we can have presentations like this in the setting of partnerships with different governments within each local First Nation, because every First Nation, although we have these grids of the Indian Act and we're separate, if you look at the DeKalb region, the cluster of DeKalb nations, you know, we have relations through all of them, but yet we're Clately, and some, like, you know, Sycas is Sycas, and but yet we used to be so close, and we have family ties within each community. So I just want to raise my hands to you, and I hope to take one of your classes soon.
Well, thank you. And I think that's important to bear in mind, the family connections. I think, for example, Brandon Prince used to work at UNBC in our Office of Indigenous Initiatives, and we were talking about an individual we know whose father is from Quedacha and whose mother is from Sycas. So there are those connections that exist, and it was also funny because we referred to him as either being from Quedacha or Sycas based on our own perspective, but he's from both. So he has those family connections, and that's not unique. So the Seymour family, for example, exists up in Quedacha. Yeah. Yeah.
So thank you for your presentation. Just a question. So reserve land, though, is held in trust by the government, correct? So that the First Nation doesn't actually even own their own land, right?
Yeah, from the federal government's perspective, yes.
Okay.
Yeah, and that gets back to the earlier question about jurisdiction. Alberta recently won its victory against the federal government regarding the federal government's regulation of energy and projects at the Supreme Court. And as I mentioned, it theoretically would be possible for a First Nation or for Indian Affairs or Indigenous Services Canada to take the provinces to court if they're regulating things on reserve, because it is federal land. I don't think they will, or they might not, but it's possible.
So then once a treaty is in place, the First Nations actually gets ownership of that land?
With a lot of
actual title to that land?
with a lot of the modern treaties, yes. Historically, no. And then we have the Shokotan in their court case. They don't have a treaty. They just own part of their traditional territory.
Okay, thank you.
All right, we've got time for a couple more questions. I believe Tash, my good buddy Tash, has a question.
I don't think it's so much of a question as just a statement, just, with everybody in the room for a little bit of understanding, is that with the Clately-Tenay Reserve, so the north side of the reserve, we're only a 20-minute drive away from town. We're not on the side with the gas station. We don't have fire protection out there. And, well, I don't know, 8 years ago, one of our houses burnt down, and we didn't have the supplies that we needed to stop that house from burning down. We had band members run into the house to save the people that were in the house. This is something that community members, living in a modern age like we do, we are terrified. I live on that side of the reserve, so we are terrified. We are extremely careful about everything we do in our homes at all times, because if a fire were to happen, we basically have to sit there and watch our home burn. There's no fire trucks that can come out. When the explosion happened with Enbridge, it was right behind our community, and we didn't know what to do. We didn't know if we had to turn off our gas. We didn't know what to do. When you leave the reserve, there's a gas pipeline going underneath the road, and that's our exit to the reserve. So we didn't know if we were even able to drive on the road past that, if we were going to be safe. We did, and when I was driving into town, I passed about 20 fire trucks flying towards the community, but they had to stop at the reserve sign. They couldn't go in, they couldn't go any further, and our band members had to sit there and choose whether they were going to stay by this big, massive cloud of flames right behind our reserve, or pass a part of the road that might not be safe for us to do. Everybody started leaving when they started feeling stuff hit them from the sky. So this is what I'm saying. The federal government, that's federally legislated land, they don't provide fire protection. Provincial, the provincial government does that. So there are things that get lost in the mix, and that was just an example that I wanted to share with everybody, that that is what Daniel, I think, is trying to explain, that the difference between federal and provincial services, and how there is such a big gap that, in this modern age should not be there. It should be closed. And I think with the three governments sitting in the room right now, I think that, that's something that should be easy enough to fix. But yeah, I just wanted to share that with everybody.
Thank you for sharing that. And one thing I didn't mention, there are a number of First Nations, particularly in the prairies, who've actually started their own police forces, their own fire forces, response teams, because of that gap. So Enoch is a good example near Edmonton. They have their own emergency response team, but even the Kainai Nation, Southern Alberta, has their own police force. So again, part of that is that recognition that sometimes the provinces don't want to cross that boundary.
Actually, Tashina actually talked about it, like the fire protection stuff on the north side. The south side, we have fire protection, but the north side, we don't, and the majority of our members are on the north side. And I have, like all our family, we're all family. Like she said, we had to watch that place go. And then to know that the fire trucks are right there, 20 feet away, and they wouldn't go on. That's what I just wanted to express as well. And also about the fact about the reserve. It is, We don't own it. We don't, like, at any time, day, minute, time, any second now, government can come in and say, Claylee, today we're moving you further up the river. We want this land. We want to expand Prince George or whatever you have. You know, we won't have that say to say no, because it's federal and it's provincial also. So if they were to come today and tell us to leave, we would have no choice.
Great. Thanks, Wendy, so much. Thank you, questioners and speakers. May I get a fantastic S2S round of applause for Dr. Daniel Sims. Now,